Your Excellencies, ladies and gentlemen, distinguished guests, it is my pleasure to also welcome you on behalf of the SSCA, this time in English. You heard our chairman, our CEO already talking about the SSCA's accomplishments and vision of the SSCA. My speech will more be about the technical aspects. I will provide you a snapshot of SSCA updates, and I will also look at certain market developments such as legislation, but also case law that we have seen in the coming year, but also years back. So please allow me to first talk about updates. New services. As for services, last year we had announced our new expedited procedure rules, our emergency arbitrator procedure rules, and last but not least, our online dispute resolution procedures. These, I'm happy to announce, have all come to life, and I will address now this year some more exciting news. We have some more products coming out as we speak. They will be going live right after this presentation. The first will be our new arbitrator selection appointment services and our new SSCA administrative committee service. I will address these in turn and then spend a few moments also on the ODR project itself. Now, coming to the first one, the arbitrator selection and appointment services have basically three products, if you will. The first one is appointing authority, the second is list-only services, and the third and final is basically an enhancement of the second, a list and appointment service. I will take these in turn. As you very well know, parties in usually ad hoc cases always have the issue of not necessarily finding the arbitrator right away, so you create impasses. Usually the only recourse left for parties is go to court, and I'm now very happy to announce that going forward, the SSCA offers a service where parties can come to us and ask the SSCA to appoint the arbitrator. All we need is the expertise and qualifications requested by the parties, and after that we will appoint. In case of any disclosures, we will give the parties an opportunity to challenge, and if there's a challenge, and after comments, we'll make a determination. If reaffirmed, our service ends there. If basically removed, we substitute and repeat the process until we have a seated tribunal. So again, that's the first service that applies to everything you can think of: sole arbitrators, tribunals with 3 arbitrators, presiding arbitrators, and so forth. So now the next service we have is the list-only service. Here, the parties have now the opportunity to come to us just for the purpose of getting names. We could give you 5 names, 10 names, or 15 names from which you can choose, and these will be given to you based again on expertise and qualifications requested. We do that usually very front up in a call at the very beginning of the process, and based on that we search our roster and then provide names to the parties. The final service is the list and appointment service, which basically is just adding on to it by giving the parties the possibility to also provide us with the authority to appoint. What that means, the parties get a list, they strike their names they do not like, they rank the remaining names, return that list to the SSCA, and we appoint accordingly the highest ranked arbitrator. We of course then also repeat the steps mentioned earlier, that is, if there is a challenge, we make that determination and repeat the process in case of removal. So those are the 3 services I'm very excited to roll out today that go live right away. It is mostly designed, of course, for ad hoc cases, so a la carte services, if you will. The next big news, if you will, is that we now have also a new service called the SSCA Administrative Committee. The Administrative Committee is designed to give parties now a platform or a neutral, highly qualified expert decision-making authority where you can request certain decisions to be made. In terms of scope, you see here on the slides, first the committee will decide or determine arbitrator challenges, determine number of arbitrator disputes, or determine place arbitration disputes. Now these 3 services will be rolled out for SSCA administered cases as well as ad hoc cases. The tribunal itself, the committee itself, is usually composed of 5 members. There have to be 3 voting members. Majority vote is allowed. Decisions are based on submissions only, and no reasons will be issued. Now moving forward to the ODR platform or the ODR protocol I mentioned earlier. This has been launched already or announced in 2018 at SSCA if you have been here. I'm happy to announce that now a few more details have been rolled out for it. As you may recall, the ODR protocol and ODR portal are designed for create or resolve disputes completely online. Arbitrators get appointed within a day. Arbitrators will determine the case within 30 days from their appointment. Everything is done online. There's no email, there's no picking up the phone. Everything will be resolved online. And again, the arbitrator will also upload the award then online. This applies to cases where the aggregate amount does not exceed 200,000 rial, which is roughly 53,000 US dollars. In terms of updates, you have seen perhaps our video earlier today. We have now integrated Cisco WebEx in case there might actually be the necessity for a hearing. So parties can use Cisco WebEx going forward. We have also further enhanced the ODR platform in all aspects to really truly have the entire process online. Again, as I mentioned earlier, no more emails, no more phone calls. Everything is run online. There's a special chat box now implemented as well that addresses any possible communications that are not provided for by the protocol. We have also provided for different enhancements in case there might be a repeat process involved. Think of an arbitrator getting removed, so the system must be capable and flexible enough to actually address those concerns and basically allow for us to reappoint an arbitrator and run the process anew from that moment in time. And finally, we have added more security measures to really ensure that whatever is done on the platform, the ODR platform that is, remains at all times confidential. Now moving on to developments. We have heard from the chairman earlier about the SSCA statutes. We have also heard about our team expansion and our new offices that we have rolled out. One more thing I'm very happy to announce today, I'm very proud of it, is actually that we have now created a so-called Rules Advisory Committee. The Rules Advisory Committee is basically there to guide and revise the rules that the SSCA already has in existence. So think of rules, procedures, appendices that actually already exist, and the Rules Advisory Committee is invited to revise whenever necessary, but also to propose and guide the SSCA by adding new services to the protocol that the SSCA has in place. We currently have 13 members on it, and here are the names, so this is brand new information. You will see ladies and gentlemen from 10 different nationalities. Most of them I see here in the room today. And they do actually come and live in 11 different countries. So it's a very diverse group of people that we're very happy to have on our side. Again, this gives us also more, and will bolster also more the international practice standards that we are trying to accomplish here, of course. Finally, on developments, we also will soon roll out a new development in terms of getting the younger generation on board. The networking platform that we will try to get rolled out after this conference is a young generation under 40 platform. We call it for the moment Young SSCA. What it will do is it will run itself basically independently from the SSCA and will organize conferences, networking events of sorts. So it's really the idea to give them a platform to exchange ideas, but also to benefit from mingling with more senior or seasoned practitioners and arbitrators and really get a more better idea of what arbitration is. So if you are a practitioner who wants to break into the market or a student that wants to learn more about arbitration, this might be something for you. So I invite you to look at our website in the coming weeks as we roll out more information. Now to the second part of my presentation, allow me to briefly have a quick look at certain market observations, in particular key developments on the legislative side, but also case law. There have been basically three big events happening just this year. The first one is the Royal Decree. You may have heard about this earlier today. The second is the government tender and procurement law that has just been rolled out recently. And just last week, we add the franchise law on top of that. I will take these in turn. The Royal Decree, as you know, has been rolled out in January of 2019. But even before that, the legislative history of Saudi Arabia has been very pro-arbitration friendly. We had the 2012 Saudi arbitration law being rolled out, which is basically based on the Untitled model law. And we have seen also the 2013 enforcement law being rolled out. Now this comes on top of everything else. And in fact, the Royal Decree reinforces Article 10, subsection 2 of the Saudi law, in that actually the government bodies can now agree to arbitrate and their dispute and subject to the Prime Minister's approval. Notably, the Royal Decree also specifically addresses government agencies and state-owned companies doing business with foreign investors. But I think the real breaking news here has been that now once the parties agree to arbitrate, they have to seat the arbitration in the kingdom. And on top of that, they have to have the case administered, institution administered by the SSCA mentioned by name, or any other institution that has been properly licensed as an arbitration center. So very exciting news here for the SSCA. The next one is, as I mentioned earlier, the new government tender and procurement law. On 1st of August 2019, Saudi Arabia's cabinet has approved this new law that will apply to all Saudi governments projects starting in November of 2019. Now, as you may imagine, we're all waiting still for the implementation regulations to really appreciate what that actually means in terms of impact on the market. But I think we can already say that this is a positive development because it really adds predictability and efficiency in the tendering process itself. Perhaps most interestingly here, parties are now officially allowed to agree to arbitrate. So you see already again this momentum the kingdom is allowing here by putting arbitration or ADR generally in the new sets of laws. The procurement and tender law is one very good example. And just last week, which caught us all by surprise, fortunately, the new franchise law went live. And here again, the franchise relationship has been more addressed and laid out. Predictability, transparency has been one front and center issues. But perhaps most importantly, Article 25 now also provides that parties can agree to arbitrate or mediate. So again, we have really an exhibition of the kingdom's intentions and commitment towards ADR in the market. Those are the three legislative laws that we have seen coming up. Now, in the next couple of minutes, I would like to address a couple of cases that have been of interest for us in general, but also for the domestic and international community. The first one is actually who can sit as an arbitrator. And we have seen now this case in 2016, which to our knowledge has not yet been contradicted or found otherwise. But it's really a reflection of what Article 14 does not say. Article 14 of the Saudi arbitration law provides that an arbitrator must be legally competent, be of good conduct and behavior, and hold a degree in Islamic or legal studies. So it does not say anything about gender of sorts, and as such, this decision has been very interesting from the Dammam court, which was the first case that really tested the waters as to what happens if a female arbitrator gets appointed. In that case, one party chose a female arbitrator, the other side pointed this out to the court, but the court did not question the legitimacy of this appointment. As a matter of fact, they moved forward and appointed and approved the entire tribunal and moved forward. So again, very positive development here. The next case came to attention very recently, very interesting. The arbitration law has in Article 40 a 12-month period by which the arbitration has to be basically finished. So it says unless the parties agree to a time frame for arbitration, the award shall be issued within 12 months from the date of commencement. Otherwise, either side has the opportunity to terminate the arbitration by asking the court to do so. Now, in this case, we had a party that basically had an arbitration where it went beyond 12 months, and that party went to the court and asked the court to terminate actually this arbitration. It turns out that the court then was asking the tribunal for the reasons why the delay occurred and found out that the tribunal decided it was necessary to appoint an expert witness, and that one of the parties, ironically the one challenging the proceedings, had not advanced its share of expert fees. So the tribunal then said basically, well, it's not our fault, it happened the way it is, and the court agreed with that. The court found that it was not the tribunal's fault that the delay occurred. Perhaps though more importantly, it found that provisions relating to the period of arbitration are just to expedite the resolution, nothing more. So this is a very important decision here with regard to Article 40. So the court basically took a very pragmatic approach in interpreting Article 40, thereby really giving the tribunal maximum competency, maximum discretion in running the arbitration. It's also a very sensible decision because, as you may imagine, parties can easily create their own delay, and then later on come around, go to the court, and trying to actually terminate the arbitration. So again, this interpretation of Article 40 avoids also that Article 40 gets elevated to, let's say, an additional ground on which you could set aside an award. So all that has been really nicely addressed by this and taken care of. The next one stands really for the proposition that the enforcement arbitration law has actually already been used. We had seen one case in 2016 where the enforcement court in Riyadh enforced an $18.5 million award that was based on an ICC award generated or actually rendered in London. And this was against the Saudi Arabian party, so it made it very interesting. But again, what was actually an eye raiser was that this was the first decision under the new Saudi enforcement law. Perhaps it may seem obvious, but it's good to have it also decided by the court that parties are at liberty to agree to arbitral procedures and institutions as they please, given that there's no conflict with Sharia principles. And in this case, the Riyadh court dismissed the case in January of 2013, in which a plaintiff alleged that the arbitration clause was null and void. What the arbitration clause provided was for ICC rules, as stated in Case A, and the plaintiff argued that this was in contradiction to the Saudi arbitration law of 2012, which the plaintiff found to be mandatory. The court basically dismissed that and pointed to Article 25 of the Saudi arbitration law, and it concluded that the parties may agree to the procedure to be adopted by the tribunal and that they are entitled to select the rules of any ADR arbitration center in Saudi Arabia or abroad, again, provided that Sharia principles are in check. Again, another decision that may seem too obvious at first sight, but again, it's important in a fairly new market to have these decisions and know where they are. The arbitral tribunal has been found that it has discretion to conduct proceedings in establishing facts. In this case, the tribunal had decided to actually appoint an expert witness. Later on, it found the expertise was no longer necessary and basically did not use that expert. The party, that challenging party, the plaintiff in that case, in that court decision, had actually basically pointed that out and was arguing that due process was not preserved. The court basically denied that motion, saying that it is okay if a tribunal bases the determination on party submissions only, and it is not necessary that the expert witness is always being used. In fact, the tribunal has full discretion on the terms of reference and the mission of that expert witness, and can, as it did in this case, shut down the expertise if not needed. Also, and perhaps finally, here, courts have also found repeatedly that they have no jurisdiction to examine merits. Again, something that may sound very obvious, but I think it's important to really point these cases out so that particularly foreign investors have comfort in coming to Saudi Arabia and actually arbitrating case in the kingdom. In this case, the party was arguing that the award was ill-founded, asked the court basically in 2014 to set the award aside. In turn, the tribunal has the court has cited Article 50, which provides for the reasons which may sound very familiar to you. The award can only be set aside if the arbitration agreement is null and void, or whether the tribunal did not respect due process, or decided the matter beyond the scope, or basically violated public policy. So those are reasons that we know from Article 5 New Convention, and the court has basically mapped out those reasons, again, citing to Article 50 correctly so. So in closing, I will say this, that we have seen a tremendous momentum in interest in international arbitration, but also domestic arbitration here in the kingdom, which we're very excited about. We have seen also lots of legislative efforts that really pave the ground for what arbitration will soon hopefully become. That is the first choice of businesses in order to determine their disputes with domestic, but also with international parties. We have also noted that the enforcement courts have remained busy. Last 12 months, they actually have been receiving 243 enforcement applications from foreign judgments and awards, so there's no differentiation at this point. And this is slightly in chime with what they have seen in the same time frame before, just slightly under it. So it's, again, good to see also that the enforcement courts keep engaged and are actually in charge of taking care of arbitration, enforcement, and so forth. And while the decisions I mentioned earlier are not necessarily binding on other courts, we see some very promising trends and the forming of established practices now in the court system. We're very closely engaged with the judiciary also in terms of education in other projects that we do in the near future. So we're very happy to see that there's a good momentum happening in the kingdom, pro-arbitration momentum. The government is on board with really enforcing it and trying to get mediation fully off the ground. So we're very excited about what happens in 2020 and the years to come. And I join you to reach out to us with any questions at any time. Visit our website regularly to find out what else is happening actually in the kingdom. And again, any questions, please contact us at any time. Thank you for your kind attention.